Hi, I'm McHan. I'm here with Brian Davalos. He's a local attorney here. He practices, I'll let him tell you what he practices.
I do a little bit of eviction law, some family law, some litigation of real property, and lately it's been a lot of eviction work, a lot of landlord-tenant work on both sides. So you get a pretty good perspective on it.
So we're going to dive in because that's a big question right now. What's going on with the eviction moratorium, stuff like that. So we're going to touch on both sides of the case, just in case you may have a need, or where you're a landlord or you're a tenant and having issues with your landlord.
Yeah. So everyone's asking, what's going on with the federal government, with the state government, local city governments.
Mm-hmm.
You got to kind of keep your finger on the pulse of what's changing. The Supreme Court just knocked down the CDC's moratorium, which they said was unlawful.
Yeah, I was seeing that today on my ride home from Escalon. They were talking about
that was all the way up. That was from the top.
Yeah,
so it's like
it's done.
Yeah, so stop. They can't do that anymore from the federal level. But you can have local city ordinances, like City of Stockton has some protections, and the state of emergency is not over yet. So there are little niche areas where you have to be careful because depending on who's in the home or residence, they could be protected.
Oh, okay.
And that works to the advantage of both ways. If you know what you're looking at in a landlord-tenant relationship, you know how to manage and negotiate that termination of that relationship, because it's happening more often than I've ever seen it. From a lot, because the market's good, and I'm seeing aggressive moves, and I'm seeing a lot of angry tenants because they don't feel like they have anywhere to go. Yeah,
that's a big problem right now because the normal turnover of home, like rentals, isn't there because there's a freeze on everything.
Or if it is there, the price for rentals in California has gone up, where people aren't getting the
that
same.
Too.
Yeah, they're not getting the nice house for the same price anymore.
Yeah,
they're getting priced up in the market, so they're kind of fighting tooth and nail to stay in there. And I understand. Many times where I think, okay, we have a deal, termination of the tenancies is coming up, and I hear from the tenant, we're not going. Where am I going to go? And they want to make a deal with me. So depending on if you know your tenant, you know your situation, you can kind of figure out what the next steps are going to be. But one of the biggest problems is if you're a landlord side is that if you don't start the process, you're behind the ball. You could put yourself back months. The process itself can take months, depending on who you're.
What are you seeing right now? Typical, like from start to finish?
4 months.
4 months.
4 months. Yeah. I mean, and if you move faster, maybe 3 months. But you're very aggressive and quick. You got to be quick. One of the things locally here in San Joaquin County I'm seeing is that the clerks are kind of backed up, and they're getting really worked with the amount of unlawful detainer cases coming in. And so they're struggling to keep up.
So are you seeing any cash for keys options out there, or do you see landlords doing that? Or
always, I mean, that's always what you want, right? Because you want to maximize your capital, your equity in a home, and get it moved if you're trying to sell it. But with the tenants having these issues of not finding a comparable rental, or they don't have the ability to go out and buy something, they're kind of hanging around saying, I don't really have another option right now. I'm going to stay.
Dig my heels in.
Yeah, I'm surprised. It's not every tenant. It's case by case. But
right.
I'm surprised by the few that have told me that they do not want to go. They want to ask for more time, far beyond what my landlord clients are willing to give. And some of them are turning down the money, which is unusual. But it kind of is a sign of the times of the market.
Right. Because I mean, I've done cash for keys for years. It's benefited me numerous times, because if I add up your cost, the unlawful detainer, the missed rent, it's far cheaper to give them a couple $1,000s to move. Well, right now that's probably a lot different.
Yeah. The incentive is good, especially if you give them the incentive to move out sooner.
Yeah.
But there are some tenants who are open to that. They're more receptive to it, especially if there's a way to work it in a return of the security deposit, regardless of what condition it's in. I mean, sometimes the risk of just the house not being in great shape, you just take that on, try to kick them back that security deposit because they know that's a fixed amount.
Right.
And then you throw a little bit more on top. But it depends on the tenant. You kind of got to feel them out, because some people do just want to go. I mean, if their families are out of state and there's time for them to leave the area.
Yeah, sometimes they have places to go, or sometimes they
sometimes don't. Yeah, sometimes they don't. California's changing, the landscape's changing, and you have to kind of adapt with it. Mm-hmm. And going into that, one of the issues I see now too is that a lot of landlords don't know what they're doing anymore, because the the laws have changed so drastically in the last 2 years.
Oh man, it's
It's a
that's
nightmare.
one of my fears as a landlord. I get caught, slipping and then end up in a lawsuit.
Yeah, a long drawn out lawsuit where a good defense attorney that's representing the tenants is going to be able to really take you to litigation, and that's kind of litigation that I think most landlords are hesitant to even get involved in. I mean, you're talking about dragging things out for another 2-3 months
While they're in the home.
while they're in the home, sometimes not paying, and then you're paying attorney fees on top of it.
So what happens if we're in litigation, they're still in the home, they win, they still remain in the house, so then I'm kind of married to them, because what's my recourse? I want you to leave, now I'm evicting them or telling them to leave because it's retaliatory.
Yeah, it's scary because sometimes you'll be with them for another 6 months. You can't, if it's a retaliatory defense and they can prove it, you're unable to touch them for 180 days. I mean, you're kind of stuck with them. You can't reissue any notice to quit. Your tenants, if they're very sophisticated, are to be able to put on that kind of defense. And if you aren't properly taking the right steps to terminate the tenancy, you are going to find yourself in a situation where a good attorney is going to file motions, they're going to ask for discovery, take depositions, and it's going to end up sometimes costing you attorney fees and the potential of a lawsuit on the other side. If you don't know what you're doing, it surprises me that sometimes that some of my clients that are landlords will tell me that they want to take these actions that are they don't understand are going to get them in a lot of trouble.
Right.
They just don't know. They don't feel like they're doing anything wrong. They're trying to protect their property themselves, and I understand that. But with the new Tenant Protection Act, Tenant Relief Act in California, if you're not reading the law and you're not doing it on a regular basis, practicing on a regular basis, you are going to find yourself getting caught in some traps where
exposure, some deep exposure. I had one of my clients, they were squatting, they filed a restraining order on her. So she couldn't even, and the city was fining her for doing repairs, but she couldn't even go in to make the repairs. So it was like she was in this catch-22. Every month she was getting like a $285 bill for not correcting something, but she couldn't go in there to evaluate it.
What you need to do is take an aggressive strategy there. You have to not only defend yourself against the restraining order, but you need to get in there and start terminating the tenancy. Right away out of the gate. You can't hesitate. The longer you wait, the more harm that comes to you as a landlord if you don't take action. Because time is money, and if you're not moving quickly, you're going to cost yourself months, weeks that could turn into a bigger problem. If the tenant feels emboldened that they're going to be able to beat you because you're not taking any action, well, they're going to dig in as well and say, well, I have no other options. Here I'm in a home for free, and I've been able to, in that extraordinary case, get someone out of the property that owns it. They're like, wow, I'm really in charge. So, you got to understand the situation you're in, because it's easy to get angry and want to lash out or do something as simple as turn off the water, but you can't do that. You need to protect yourself and do it right with the proper notice. And that, that's something that I was getting to earlier, is that if you put the wrong wording in the notice, and you don't do the right type of notice now under the Tenant Protection Act, you're going to end up costing yourself months of time and starting over again with a whole case that's really going to cost you a lot of stress if you don't do it right. I mean, you can literally issue a notice to quit, you try to go forward on it to an eviction action, come to find out it's deficient. And you didn't do it properly because the laws have changed.
You put the wrong word in there.
You didn't do the right.
You put a cause instead of a no cause or some.
Yeah, you must have. All those fine details that used to be, specific to the major metropolitans like San Francisco and then places like Berkeley and Santa Monica, which now are statewide, and the ability for a defense attorney to exploit those is kind of what some tenants are willing to pay for nowadays. If they feel like they have no other options and they have some money socked away, they're not going to pay you rent. Well, here they come. They're going to try to stay.
Hire an attorney.
They'll hire an attorney, and the next thing you know, you're hearing from someone who knows what they're talking about, and you did something wrong, and now you're starting over from scratch. And that's the scary thing. I think most smart clients that come to me are the ones that know they don't know enough. They're like, okay, I don't know enough, but I want to get my house sold. I want to, for whatever reason, get out of the market, get out of the rental market. I need to fix it. And they come to me and I say, look, good thing you did, because it looked like you were going to fire off something that was going to hurt you in the long run. So
I couldn't even imagine.
Yeah, it happens a lot, and it's been happening a lot lately. So I just recommend that anybody do some little research before they take any action on their own. I mean, it's fine, even if you just consult with an attorney, you know, and talk to them about your situation, that's probably better than
30 minutes is well worth.
Absolutely. I've had people come in and talk to me for 30 minutes and go, okay, good, now I know, because I was going to do something different and get myself into some trouble.
Yeah, before the whole new statewide, I ended up evicting somebody, and even after I did everything right, he still come back after me, claim I was discriminatory against his disability. I didn't offer him the lower level.
Small claims actions against
It was some type of through the state of California.
the Department of Fair Housing.
Yeah.
You can get all kinds of discriminatory claims on race, disability, income, sex. Sometimes you can get things where you get pulled in small claims court and you're like wondering what happened.
Yeah.
You know, and that's why it's important too. Another step that is missed in a lot of cases, if someone hires maybe like a document preparer to help them with their eviction to evict their tenant, and they
A lot of people do that.
A lot of people do that. They save money. It saves them money, and it makes sense in a lot of cases. But there's another step that you miss where the landlord doesn't get a full release of claims when they settle. Sometimes a lawful detainer action begins. Landlords are in pro per representing themselves, and they go out and they start firing off the service of the process of lawsuit. And next thing you know, they're getting into a settlement agreement. You know, the tenant is working with some kind of nonprofit or a mediator at the courthouse, and they come to a deal. But one of the things that gets missed on occasion is that you need to make sure you get a full release of claims. The last thing you want is someone coming back on the back end and saying, well, I didn't release my right to file a small claims lawsuit against you. I released possession, but that was it. And you released non-payment of rent against me, and you dismissed the lawsuit, but nothing else was actually released.
Wow.
So that's a step that's pretty big that should not be missed.
Yes.
In settling with
Take note.
settling with one out of 10. But I just really think that the smart homeowner, smart rental owner is going to take the steps necessary to move quickly to get their house on the market. Because, with the way the market's shaped right now, I think if you're going to look to 6 months to a year, we don't know where it's going to be, you got to get moving.
Yeah.
Get that thing moving to the market, get it moving to sale, and start the process with someone that's going to guide you properly. And one of the biggest issues I have is I see landlords, they got to deal with a lot of stress from, sometimes you got a property manager that's not really on your side, which is hard.
Yeah, it seems like I've heard stories where they feel the property owner feels like the property manager is siding with the tenant.
It happens often because there's a long relationship with some of these tenants and these property managers. They'll move these tenants from house to house and they have a relationship with them. And so you have to be careful who you have as your property manager too, because that third party kind of can become a middle person that can either help or hinder you, and give you the right information or not give you the right information. If you get to the point where you feel like this person's truly not on my side and not giving me the right information I need, it's a conflict. I've seen that happen, and I really recommend that if you are going to hire a property manager, you make sure you understand the terms of your agreement with that property manager, because if someone like you comes in and wants to sell the house and that property manager is causing some interference, now not only is that homeowner dealing with the tenant problems, but they're dealing with the property manager problems. And here comes a realtor like you saying, hey, this is a great house, let's get it to market. The property manager saying, well, I have all these interests and like the tenant has protections. And also the property manager's advocating for the tenant. They're like, wow, now I have a two-headed monster. I just wanted to deal with getting the tenant out.
Because sometimes property managers, they feel that they're entitled to that listing when that relationship could have been on the rocks a long time ago, and they don't trust that property manager anymore to represent them to the fullest capacity. So they bring somebody in like me in who, we don't have that long conflict. Yeah, there's no conflict. So I'm telling them, hey, we could sell your home for $500,000. And they're like, yeah, let's do it. And then the property manager is like in the way, interfering.
Yeah.
They're not.
It happens more often than you think. And one thing that scares me for landlord homeowners is that, are you signing a property management agreement that gives that property manager the exclusive right to be the first listing agent if you decide to sell it within a term? So you need almost like a right of first refusal. You need to be very careful who you choose as a property manager, making sure that they're
I've never even thought about that.
They should be ethical. They should be. There should be a conflict, and you need to understand what relationship your property manager has with your tenant. Because if there's a close personal relationship with that tenant that goes back decades, they're not going to be on your side.
Yeah.
And you really need to protect yourself from someone who you think is a fiduciary and someone who you think is going to have your back, that's a dangerous situation to put yourself into.
So who's the, technically, when you're speaking fiduciary, who's the property manager's fiduciary responsibility to?
If you're disclosing, just like a real estate agent is disclosing a buying and a selling relationship, there can be that mutual relationship between both, but I just think it's a bad idea. I think in general, if I'm looking at having someone manage my property out of state and I meet with this company, I'm going to want to know that tenant isn't someone that they have a long-standing relationship with, because I think that's where the conflict develops. And they're going to look out for themselves because they know that tenant's consistent, they know them, they're going to want to keep that tenant in place versus, hey, maybe I decide to change my mind halfway through this lease and go, I want to sell it now.
Right.
They're going to protect their own interests in that tenant. That's a good example of when you want to get out of the rental market and you want to get your house sold, you can run into something like that. You can run into a tenant who understands the Tenant Protection Act and can delay you if you don't file the right notice to quit.
So you're bringing up points I've never even thought about.
Very careful. Well, these are points that I've run into personally.
Yeah, right.
In my practice.
And I know tons of people out here and YouTube and Facebook, you probably haven't even.
No, I mean these are the hard-learned lessons in the trenches that you have to go through it. You have to see people deal with it and go, wow, that's not the way this should be happening. But when you're in the business of the rental market in California, in the last 7.5 years I've been practicing, you just start to see that this market is very tenant-friendly, and it's to the benefit of it's my benefit when I'm defending a tenant, and sometimes it's a benefit if I know the law when I'm representing a landlord.
Right.
But in general, I think you just have to understand it really well. Otherwise, you're going to put yourself backwards months in time, and then you could cause yourself a lot of stress and put yourself in a bad relationship with property managers, tenants. You might have to hire counsel. You don't want to create a bigger problem for yourself by doing it wrong in the beginning,
right?
Because then, like I said, you expose yourself to those lawsuits. You expose yourself to a year and a half, 2 years of having a tenant in place, where if you had done things right in the beginning, you maybe wouldn't have been so bad. I've had those nightmare scenarios where the client comes to me and they go, look, we've been trying to do this for over a year now. I said, well, it's because you guys did it wrong from the beginning.
Yeah.
And you try to take, the more, budget-friendly route, but it ends up costing you some money in the longer run.
Right. I think a lot of landlords try, because they sometimes have that long-term relationship with their tenants, so they're friendly, and I'm guilty of that too. I feel like these people are my friends. I've taken care of them. I've cut them breaks. But at the end, when it's time to transition,
it gets ugly.
Yeah.
But what I recommend is you're not too friendly to the point where you're not following through with the unlawful detainer lawsuit. And I know it sounds harsh, but if you don't have that leverage of the suit to negotiate the deal, you're kind of just at a stalemate. You're not moving forward. You're standing still, and you could be moving forward. And some people that I talk to, some of my clients, that they walk away sometimes and they don't want to go my route. They don't want to hire me. They just want to try to work it out. But the problem is, a lot of them come back to me later on and say, wow, it just cost me 2-3 more months because I thought I was going to make a deal. I thought we had some kind of understanding, and here I am now back with you, starting all over again from 3 months behind, and I could have been forward by now. So there's nothing wrong with making some kind of settlement agreement, or we call it stipulated judgment. I want you to have a judgment as my client, landlord, where you have the writ of execution for possession in your hand, where if there's not certain conditions that are met, that we can go down to the sheriff and we can make sure that the eviction is completed.
So let me ask you this. You said once you get the writ, does it go on their record, the tenant's record?
In most cases, the cases stay sealed, and we can even dismiss it after the fact, after writ is issued.
Okay.
In most cases in California, I think they're sealed. It's difficult to find someone's eviction. And you can agree to dismiss it, you can agree to keep it sealed, file that with the court. And you can place a lot of conditions upon any kind of settlement, that are fair for both parties.
Yeah, right.
You can make sure that they leave that place in good shape. You can make sure they get some money back at the end of this thing.
Right.
You can make sure they get the time that they need, but they have a date certain they must be gone. And all those things can be negotiated. I like to end the case that way. For me, it's best that there's a deal made where we have security, and the tenant doesn't feel like they're getting pushed out. There's some kind of middle ground that we find.
Right.
But it's all.
But you have the writ.
You must have the leverage. Yeah,
you have the leverage to have the sheriff come
and to finish the thing, to finish the eviction if it's necessary. You don't want to start from behind and start over again. Start the ball rolling, get it going, so that when it's time, if there isn't compliance or the agreement isn't met, then you can move forward and have some type of resolution, rather than an uncertainty of another long drawn out, unlawful detainer case where you thought, hey, we had a deal. That happens sometimes when someone goes, hey, can you just draft something up for us? And it's almost like a contract in a way, because there's no writ of possession, there's no judgment in unlawful detainer jurisdiction. And so it's your choice. I mean, you can work with someone and until you feel like you can't anymore. But I always recommend, look, if your mind is, hey, I want to get my house sold. My mind is, I want to roll it.
Start now.
Yeah, just start it. Just start the process, and then you can work. You can work with your tenant. You can work with your attorney, and
the money would be well spent. Okay? Because if you're 3 months into this thing,
yeah, it's just 3 months of rent, 3 months behind the market. I mean, you could have got it sold, and for me, when the market's hot, you got to move. And even if it's not, you still anybody that wants to sell a house, guys, get it going. I've seen people just so stressed out over the issue of tenant either not paying, treating them badly, taking advantage of them, and vice versa. There are a lot of tenants who have the same things happening to them with the landlord. And that's why I've learned that being on both sides of these cases has really informed me to be a better attorney for people.
So let's talk a little bit about tenant issues, like tenant landlord. So where the tenant is hiring you, what types of situations have you run into?
Some really just bad behavior on the tenant, landlord's part. I wouldn't even call it, it's more like evil behaviors when I say, those are the kind of cases I take, where someone is using means to evict someone out that are illegal, that are fraudulent. For example, they'll shut off the water, they'll turn off electricity, they'll block access, they'll harass and threaten. They will, in one case in particular, they'll intentionally omit the tenant's names from the lawsuit so that they can get a faster result. They'll file false proofs of service to get someone evicted quickly. And those cases happen often because what happens is when you file an unlawful detainer lawsuit, a notice goes to the tenant from the court. The court wants to make sure everyone's playing fair.
Right.
So the court sends an actual notice to the address, and unless you're a very sophisticated and really devious landlord, that notice is going to get to the tenant. But I've even heard of cases where the landlord will intercept that letter somehow. Whether we catch it on video or we had a witness saying that, look, the landlord went in and grabbed that mail so that they didn't get notice of it, filed a false proof of service, got a default judgment, and we're able to evict that person. I've been able to catch these cases right at the end. Right at the end of the case where they're about to get my people out, I move in quickly to stop the landlord and file motion of practice that will get my client their day in court. So you have to be careful. There are attorneys who are willing to do that, willing to act unethically or unlawfully to get you possession. But the problem is that if long term that tenant is really angry enough or really has the means to hire counsel, they're going to go out there and do that. They're going to come to someone and say, look, I can prove my case. So these are the type of cases on the tenant side that I've worked. And right now, with the way the market is, you've seen a lot of aggressive landlords pull some moves I haven't seen before in my career to get their house sold because they want to make that money. And that's what we call an efficient breach. They're willing to take the risk to get it to market so that they can get it sold. They don't care if there's a lawsuit at the back end. Maybe they'll throw it to their carrier. Maybe their carrier will cover litigation. But
carrier, what do you mean by that?
Their insurance, the homeowner's insurance sometimes will cover them. They have some kind of policy that will cover them for any kind of a lawsuit for fraud or any kind of tortious conduct.
Okay.
But I say that to the landlords out there because I don't think that's a good idea. If you're going to try to take action like that, then you need to be ready for the back end of it. If they fire back, because if the evidence is there, then those are good cases for tenants. I've had really good results with tenants who brought me the right facts and said, look, the landlord did this unlawfully. And I go, wow. Okay.
So what happens at the end of that? So the tenant stays in place through the whole court?
No, I'm talking about some cases where the tenant's been evicted, actually.
Oh, okay.
And they can't believe they've been evicted. They said, we don't know what happened. We think it was a retaliatory eviction, wrongful eviction. There's a bad faith.
Yeah, because I've had people call me, they want to rent, they've had eviction. I got evicted, but I didn't even know I was being evicted.
Yeah, it truly happens. It truly happens. And for the someone who's just not paying attention to the mail, doesn't understand the unlawful detainer process as a tenant, they're going to get pushed out. They're pushed out hard. You have to know what's going on. You have to be able to find the right attorney. I've had a lot of people come to me and go, man, I wish I would have found you a month ago, 2 months ago. And sometimes they come in my door and I say, I wish you would have found me a week ago. Give me more time to breathe. Because sometimes people drop fire, I call it, drop an emergency in my lap, fire in my lap to put it out. And, we're talking about trial tomorrow, trial in a couple days. And it doesn't give me the time to really build the case to defend the landlord.
Right.
Or even a tenant. Either side, a lot of times these litigants get themselves in trouble and they're not being careful.
You run up against a lot of slumlords, so to speak, or
I've seen it all. Yeah, I've seen it all.
What would you see more of? Slumlords or people just making mistakes as landlords?
I see a lot of, lately I've seen a lot of frustrated landlords because of the Tenant Relief Act. Mm-hmm. And the fact that there have been protections for tenants that have been extended for so long.
Right.
I'm seeing more frustrated landlords coming to me because they don't know what to do next. They don't feel like they have any options. They're frustrated.
Because they're still having to make the payment.
Yeah, they're feeling hopeless and they're like, what do we have to do? What can we do? I mean, I don't want to do this anymore. I can't afford to do this anymore. So that's why I give them their options. I say, look, tell me what's going on. Let's sit down and talk. Show me all your documents. And it's important to have a written agreement. If you don't have a written agreement, it's even harder for me to back you up.
So month-to-month, verbal month-to-months or no?
So some of those, yeah. I mean, the ones I feel for the landlords are the homeowners when they let someone live in their house with them. You take over a room, or a couple rooms, or the in-law unit in the back, and then they just get terrorized for whatever reason, one reason or another. Wow. And so those are the cases where, like you said, there's possible restraining orders, fired back and forth. There's more aggressive conduct, and you're not really separate from that tenant.
Can you imagine having to restrain over somebody in your own house?
Hey, the thing is, and you get served with one of those, you need to fight it because it happens quickly. It's not something that is going to drag on for months.
Right.
You're going to get into court pretty quick on a restraining order, probably within a month after being served. So, those are things where you need to reach out immediately, especially as a landlord if you've got, force what's called a move-out order. You can't be there anymore. You can't be in your own home. You have to be very careful. Now, you can go there with a civil escort from law enforcement or send some friends over there to get your things out. But you're going to need to be represented.
Could you imagine being kicked out of my own home for...
it's rare, but it happens. It happens.
Yeah, I'm sure it has, for sure.
Yeah, it happens to homeowners. So, in this day and age, the best thing is to be informed. Don't take the wrong steps. And if you take the wrong steps, you got to be willing to pay for them in the back end if things don't go your way. Because it's so easy to think, okay, I'm doing what I did 5 years ago, 10 years ago, or I did what my uncle or my dad or mom did with their rental. I'm still doing the exact same thing.
It was easy back then.
Yeah.
It wasn't easy, but it was easier.
Yeah, and it was more clear. The lines were more clear back then.
Mm-hmm.
It was a typical 30 or 60 notice to quit, or a 3-day notice to pay rent and quit. Right. And now those things have all changed to the point where even attorneys that practice this area of law are still learning how to handle it going forward. And we're working with the courts who are also trying to understand these new laws. There's so many of them now, and as you have the pandemic continue and go on into 2021 here, we don't know where we're headed with the tenant law. We're not sure,
right? And
we don't know what's going to happen in September when this latest moratorium from the governor here in California expired. We don't know if the legislature will extend it again, and we're not sure. We have to pay attention. Like I said, make sure your finger's on the pulse of these areas of law, so that you can guide your client. You may take the best steps to get your house sold. Because at the end of the day, in California, what I really recommend to a lot of my clients is, look, I love the fact that people have rentals. If you have good tenants and you have a good landlord-tenant attorney, no problem. But if you have 1 or 2 rentals and you're kind of, maybe just doing this as an investment, you have a diverse portfolio, sometimes it's time to get that thing sold. Because with rent control, relocation assistance that a lot of people don't know about, you got to relocate your tenants in some cases. You're not putting the right language out there and writing to them. You're putting yourself in some trouble. You're getting yourself into a mess where the court can say to you, hey, you didn't comply with this and this. There can be local ordinances that you need to comply with.
It's scary to be a landlord right now.
It is, but it's not. There's nothing wrong with it as long as you educate yourself and talk to the counsel and have someone ready.
So speaking of talking to counsel, if somebody is having an issue, whether you're a tenant or you're a landlord, how do they get a hold of you?
I would go to the DavalosLawFirm.com, look for me online, Brian Davalos, and schedule an appointment online with my website,
okay,
or call in the office and talk to one of my staff and schedule an appointment.
What's the phone number there?
It's 209-400-4517.
Right.
Yeah, call me there. Go to the website, but just don't take any steps without educating yourself a little bit more first, because what worked 2 years ago doesn't work today, and what works today might not work tomorrow. We don't know yet. I'm always careful. I'm always checking, getting updates on what's happening.
important.
Yeah, because right now the most recent update was the Supreme Court ruling against CDC. Next, we're looking to end of September. What's going to happen with the moratorium on evicting based on non-payment of rent? You know, we're going to see what happens. And I think that if you're truly in the market to get your house sold, you need to take the right steps now and not wait.
Call Brian.
Yeah.
And they call Lance.
That's the way. I mean, you got to have a good team. Have a good team
Yeah.
that are ready to go. Because, you know, we can work together.
Yes.
We can bounce ideas off each other. You have a lot of experience as a landlord yourself, me dealing with both sides. And I think that a creative strategy and going in there aggressively, respectfully and aggressively, so to get something done is the best way to do it. And there's no need to treat anyone with disrespect. There's no need to be rude to anybody. People do take offense when the council shows up, but it's my goal, and I think it's your goal too, right? Is to smooth the transition out and get the house sold.
Absolutely.
Keep everyone happy as best we can. If you have to be stern and use the legal process, that's there for both sides, for tenants and for landlords. So, you know, don't be afraid to talk to somebody and get somebody on your team.
Absolutely. So thank you guys for joining in. And remember, if you need to sell your house, yes you can with Lance McHan.